And for whatever reason, our Supreme Court backed away from that, which doesn't make sense to me. It really doesn't. And to be candid with everyone, it makes my job much more difficult. Okay, what's next? Yes.
Thank you.
So, gentlemen, what's next?
I think it's Milwaukee's motion for new trial.
Okay.
Good afternoon, Your Honor. It's Smith from Milwaukee.
Sir,
Do you mind if I stand here?
whatever's, you can stand there, or you can go to the jury box. You can approach the lectern, sir, whatever makes you comfortable.
All right. And staying right here will make me very comfortable.
Or whatever you have all your stuff set up, right?
I don't know if I'll ever have my stuff set up. And I will try to be brief, although I've been warned by a couple of people here that those are famous last words when it comes to attorneys. Let me deal actually with a similar but slightly different issue, and this is the Jason Brown email from February 22nd, 2019. Milwaukee had disclosed this email before the close of discovery. I don't want to focus too much on all of the issues with the email, but I do just want to talk briefly about the responsibility of both parties, right? There was arguably, the plaintiffs are asserting that there was a 16.1 violation and that this was an email that we wanted to use in our case, and that we had produced timely, meaning at the time that we initially knew about the email. Of course, we have all of the evidence of Mr. Brown's illness, COVID, et cetera. But the other piece of it is the obligation of parties to bring discovery issues to the court in a timely manner. And Wright Miller talks about Rules 37 sanctions and how they need to be timely sought as well, preceded by me concur. There was an opportunity within the ordinary discovery period, since this had been disclosed before the close of discovery, albeit after Mr. Brown's deposition, to discuss this issue, to talk about whether there could be a way to remedy the late disclosure of the email, et cetera, et cetera. But it's difficult to do that when parties don't confer about these issues and proceed to trial. We listed this, of course, as an exhibit in our pretrial memorandum, but plaintiffs didn't bring it to the court's attention through a motion. So now we're dealing with this issue at trial. I recognize that if this had been brought up in say, a motion to compel or a motion for Rule 37 sanctions at the appropriate time, then perhaps we could have had this discussion then. But by the time
But are you saying that that's a condition or requirement prior to filing a motion to eliminate, exclude evidence?
I don't know that they needed I don't know that they needed to file a motion eliminating specifically on that topic, but they, at least at some point during the discovery period, if this is an issue that arose during the discovery, which, as we know, the email came after Mr. Brown's depo, then yes, it would have been incumbent on the party, whether in a motion eliminate or in some kind of discovery motion for Rule 37 sanctions, to raise the issue with the court so the court could address it. But I don't think that trial was the appropriate time to raise that issue.
I mean, you can't object at trial?
Well, of course you can object to trial, but the basis for an objection to trial would be an evidentiary objection. Actually, that's a good point, Your Honor. Right? You have your evidentiary objections, right? Is this hearsay? Does this is this speculation? Is it speculative evidence, et cetera? Is there a lack of foundation for this evidence?
Or objection, judge, this is new evidence. It's never been produced during the course and scope of discovery. Right? Isn't that a valid objection, judge? This is a new witness. This is somebody who's not been identified. The discovery closed 4 months ago, judge. Is that a valid objection?
I agree. That would be a valid objection. If the email had not been disclosed at any point during discovery, if it hadn't been disclosed leading up to trial, and if for the first time we're seeking to introduce something, even after the calendar call, we're seeking to introduce something for the first time, I agree that would be an appropriate basis to exclude that evidence. But here we're talking about evidence that was produced and that plaintiffs were aware of during discovery. So again, I don't want to spend too much time on this one issue, but it was an extremely important piece of evidence for our case. The prejudice is palpable because plaintiff's case against us was a failure to warn. And this email provided the very warning that they said didn't exist. In fact, they elicited testimony during the trial that seemed to suggest, that did suggest that no such warning ever been given, contrary to the email.
And I want to make sure I understand where you're going with that. I want to make sure I understand factually what you're saying.
Well, I'm talking about so it's twofold, right? I don't think it was appropriate for plaintiffs to object on that basis at trial for the first time after it had been produced in discovery. We proceeded to trial on the assumption that because they had not objected, had not filed any sort of motion, had not sought any sort of sanction associated with the disclosure of that document, that in fact their objections, if any, at trial were going to be limited to ordinary evidentiary objections, not to the fact that, although it had been disclosed during discovery, it wasn't disclosed before Mr. Brown's deposition. So, and then the second piece of it is the prejudice to us. And I think the prejudice, for purposes of whether this error was harmless, I think is absolutely harmful because that was a key element of our defense to be able to show that the warning the plaintiffs insisted ought to have been given and that the jury found ought to have been given was in fact given. Let me move on to the stipulation between Real Water and plaintiffs. And of course, as your honor knows, there's a difference between stipulation among all parties and a stipulation between fewer than all parties. EDCR 7.50, which basically echoes a district court rule 16, indicates that a stipulation among fewer than all parties may be effective to stop the parties that entered into it. But otherwise, it's no more binding on third parties than it would be than would any other agreement. In fact, if a stipulation that's between, again, fewer than all parties purports to state something that they don't have foundation for, then it does not have any effect at all on the third parties. So Mr. Polsenberg and I were different parties in the case. We could stipulate that 2 + 2 = 5, but if we don't have a foundation for it, certainly it would not in any case be binding on other parties, and then it would not have any effect at all if there's a lack of foundation for that. Here, I don't think that there is a foundation for the parties' stipulation, and at the very least, it's an issue that we should have been entitled to explore with the jury, because again, this is not an expert. This is not an expert making a stipulation. These are parties making a stipulation. So we would have been entitled to probe the plaintiffs and Real Water about the basis for that stipulation, including Real Water's motivation, if any, in entering it, including the fact that they're in bankruptcy and that there are potential advantages to there being an opportunity to shift blame to another party, such as Milwaukee, a solvent defendant, as opposed to
I don't think it was really a shifting of the blame, because remember, this is a strict products liability case. And the defendant, the key defendant has an opportunity to admit liability, because the facts were pretty clear. I mean, you don't expect hydrazine to be in drinking water, right? And so what Mr. Odou did was, and I understood exactly what he did. He really didn't have much of a defense. And so he didn't want to needlessly offend the jury by presenting a defense that might not be viable. So he has a right to stand up and say, look, judge, we did something wrong here and we apologize, and so on and so on. And lawyers do that all the time, right? So he didn't even need a stipulation to do that. He could have just walked out with Mr. Kemp unknowingly and an opening statement and said, look, you know what, we decided, and we've looked at this case very closely. Ladies and gentlemen, we admit we're responsible for these unfortunate injuries. Could have done that. And that happens from time to time.
right. And in a two-party case where there's one plaintiff and one defendant, that makes it extra easy, right? You could stipulate to issues, you could stipulate to facts, you can even stipulate under Rule 41.
But but we're not talking about stipulating the facts. We're talking about an admissions of liability, right? Which is something that happens from time to time, and that's very important. you know, and I kind of, you know, hypothetically, we can look at it through this lens. Mr. Odou maybe could have come up with some sort of novel defense, and the jury might not have respected that position. And they could have been hammered more, right? And so my point is this: sometimes you don't have the facts to support your position, and sometimes it's better to, you know, say, ladies and gentlemen, we're sorry. That's what Mr. Odou said. So he has a right to do that. And I don't think he has to stipulate to that either.
Well, I mean, but I think it does make a difference if there is a stipulation, in fact, and the jury's told that in fact real water is liable as a result of that stipulation. I think that sends a message to the jury that is different, and that the court needs to be cognizant of the effect that that's going to have on other parties to the case. So our
So you're saying it's error for the target defendant, the manufacturer, to admit liability in open court before a jury?
I think you have to be extremely careful on how you do that. And then if in fact there is going to be that sort of admission of liability, there has to be an opportunity for the other defendants to explore the basis of that stipulation in front of the jury, including
What would they
issues such as
do? How would you explore that? I'm curious, how would you explore that?
You would have to.
Because unless there's an issue regarding fraud or something like that, and that wasn't there. I mean, a party has a right to admit to liability, right? I mean, what would you explore? Sir, why do you admit you're responsible for a liability? Have the witness on the stand? Well, we think it was a defective product and we just want to step up to the plate and accept responsibility for it. Because water should not include, as part of this formula, rocket fuel, right? I mean, that's kind of, I mean, I'm just putting it down to what it really and truly is, right? And hydrazine, right? And just as important too, you remember the evidence was not great for Mr. Odou. What was it? How many titanium tubes were there, Mr. Odou?
There were 2 that were recovered at the end of the business.
Right, and these were from the former Soviet Union, Russia, right? And it was part of their rocket program and so on and so on. I mean, those aren't the best facts.
UNFW tested 7 out of 7 retail bottles of water and found hydrazine. There's not a lot we can do with that.
Right. Because facts do matter. I'm quite sure if Mr. Odou had something that would have helped him, he would of course grabbed onto those and developed them accordingly.
I don't doubt that, Your Honor. I would also just point out that, as Your Honor pointed out earlier today, by the time Real Water was at trial, the company itself was already annihilated, right, for purposes of punitive damages. So it's not exactly the same case as if you have solvent defendants, each of whom has an independent and equal interest in making sure in protecting their company from issues of annihilation.
But your client had an opportunity to protect its interests too, right?
Well, not fully, because now we're in a situation where the case against Milwaukee, which is derivative of and predicated on there being a finding of liability against Real Water, half of that case is already proved by Real Water's stipulation, because the jury would hear that, and that does not give us an opportunity to defend. Milwaukee had a right.
So you're telling me distributors don't have an opportunity to go out and check and find out who they're distributing products for?
Well,
What was it called? HACCP? What's all that, you know? HACCP, right? Remember the HACCP issues in this case?
well, I just want to point out, we're not a distributor, right? We're a manufacturer.
I understand
of a
that.
separate product.
Right.
And I will get to that in a minute, which the difference between the products and how that relates to there being strict liability and products liability and the issues of offset related to that. But let me move on for now. I do think that we should have been entitled to probe the basis of the stipulation, and also to get into the fact that, yes, there is a difference when a party stipulates to facts knowing that they're already in bankruptcy and that the what is going to, the result of the judgment. in this
Do
case.
I, as a trial judge, should I consider whether somebody's in bankruptcy or not, or whether they have insurance coverage? Or any of those things,
Well, if
when
we're
it
talking,
comes to a stipulation or admissions of liability?
yes, Your Honor, because in this case, you have to look at the motivations behind the stipulation that the jury would be entitled to hear if you've got a co-defendant who hasn't stipulated. Because now you're in a situation where
But you were given, your client was given an opportunity to defend your case, right?
it makes it a lot harder to defend our case when
Because you
the
have,
party that actually manufactures the product has already admitted it. But I do actually, Your Honor, I meant to mention this at the beginning. I do enjoy arguing in front of you. I expect we're gonna not agree on everything. We'll probably disagree about a lot of things. But I appreciate the attention and respect that you give even to arguments and positions that you may not ultimately adopt.
well, I don't mind telling you this, I learned listening to counsel, I do.
Well, let me move on to expert testimony.
And plus, I think it's important for you to make your record. I do. I respect the process.
No, I absolutely appreciate that, Your Honor. We've already had a few comments about appellate counsel not necessarily knowing every detail about what happened in the case. And I'll be the first to admit that I do not know every detail about what happened in this case. So I appreciate your insight and the insight of trial counsel in helping us along here. Let me address briefly the expert testimony. We had we had more than three experts, but we had three experts that I want to address today: Dr. Tenner, Dr. Hull, and Mr. Babcock. And in practicing these, I do want to focus on what I think it's been a debate that Mr. Kemp and Mr. Polsenberg and Your Honor and the Supreme Court have been having for a while, which is the proper interpretation of Williams versus District Court and what it means to contradict a plaintiff's expert opinion. We know that.
Well, that way, I happen to be the trial judge in that case and I was affirmed. So tell me what I need to know.
I will
Trial judge?
Yes, I was.
You and,
Mr. Kemp said they named it after me. Really, I didn't. I think that's what Mr. Kemp said.
the
Go ahead.
Williams was in the other case. The case in front of
They were consolidated.
Digital, that's right.
Right. They were consolidated.
That's right.
So which part of it do you have questions on? Independent alternative causation theory, plausibility theory, or cross-examination?
Well, I think all three are implicated, but when we're talking about the three options, when I think we do have a disagreement with plaintiffs about the meaning of the expert testimony to contradict the plaintiff's causation theory. Now, of course, as a plaintiff in a case with medical causation,
But what do you got to fine tune that for me a little bit.
absolutely. Yeah, let me. Sure, I'll go there right now.
Fine tune that for me because I think I know what it says, but I can.
So I think the nub of our disagreement is what it means to consider the plaintiff's causation theory, because that's the chief difference between the option of contradicting the plaintiff's expert versus proposing an alternative causation theory, right? Alternative 2 versus alternative 3.
But you got to be more specific than that for me. And then here's my point. I mean, whether you look at Williams, you can look at Morsicato, you can look at Giglio, you can look at Perez versus Las Vegas Medical Center, you can look at Brown versus Capan, and these are all the medical causation cases in the state of Nevada. In a general sense, if you have someone opine on injury causation, they have to testify to a reasonable degree of medical probability. And then you have the lower threshold, notwithstanding that, and that's what's called plausibility theory, right? Under the Williams case, right? If you're going to offer up a plausible theory, number one, there still has to be the appropriate foundation for that plausible theory, right? You just can't guess or speculate or anything like that. But if you're going to opine less than to a reasonable degree of medical probability, more likely true than not, notwithstanding that, you still have to accept the plaintiff's theory under Williams.
Yeah, and I think that I think you've highlighted where we read the opinion a little bit differently. Because I don't recall in Williams versus District Court that there's ever a notion that you have to accept the plaintiff's causation theory, that the defendant's expert has to accept.
Well, if you don't accept it from a plausibility theory, then they have to opine to a reasonable degree of medical probability.
Well,
That's independent alternative causation theory.
so recall again that the plaintiff bears the burden to prove with expert testimony that the plaintiff's injuries were caused by the defective product, right? That's the plaintiff's
That
burden.
goes back to Las Vegas versus, Perez, Las Vegas versus, that's Perez versus Las Vegas Medical Center back in the 80s. I mean, that goes back. I'm familiar with those cases.
Right, and of course, the defendant doesn't even need to put on an expert to traverse the plaintiff's case in chief. Even if the plaintiff has a prima facie case of medical causation established with expert testimony, one of the methods that Williams endorses is cross-examination of the plaintiff's expert, right? Because the jury on cross-examination.
You know, this is one thing you have to be really particular with when it comes to cross-examination. You just can't ask questions where there's no foundation for it. For example, well, could it be this? Could it be that? No, you can't do that. There has to be a foundation for that. It has to be a factor based upon the plaintiff's medical history. But go ahead and bottom line it. What are you saying from a medical causation issue in this case? I want to make sure I understand that.
Well, I think the bottom line is Dr. Tenner, he did present an alternative causation theory, but even before that, he contradicted the plaintiff's experts. And
Did he opine to a reasonable degree of medical probability?
But you don't need to do that for just contradicting the plaintiff's experts, right? Because in that instance.
Contradict? What do you mean contradict? Define that for me. Are you offering up an independent alternative causation theory?
Well,
And if you're going to contradict it, there has to be an appropriate foundation for that, right? There just has to.
I agree with that.
And I don't mind telling this as a practitioner. I remember it would drive me nuts. I'd have cases and cross-examination. Well, can't diabetes cause this? Can't this do that? And I'm sitting there, objection, Your Honor, there's no foundation for that.
Well, Your Honor, but part of the plaintiff's burden in producing reliable expert testimony to support their causation theory is to make sure that they have, in fact, considered alternative causes to the plaintiff's injury. And so,
well, that's more differential diagnosis. But I'm getting to the point of if the plaintiff's treating physician gets on the stand, he's reviewed the appropriate medical records, he's come to a conclusion to a reasonable degree of medical probability, more likely true than not, that this liver injury was caused by this exposure. That's enough to go to the jury.
Well, and it would be enough to go to the jury for a defense expert to also get on the stand and say, here are the problems in the plaintiff's expert's analysis, right? Because the hallmark, that the gatekeeping function that the court performs at the hallmark stage.
And I'm not going to disagree with you, but I think the only thing I need clarification on when you say problems, what are we talking about, right? Because if hypothetically, if there were problems in the analysis, and say, for example, it didn't meet the assistance requirement, we can handle that pre-trial motion. We can look at it and see, okay, is there appropriate foundation for this opinion? Has it been tested? Is it peer reviewed? And all those wonderful things that they talk about that are part of the assistance requirement.
Right, but even after you go through all of that, not all experts are going to agree, because in that case, you would never need to have expert testimony in trial. It could all be taken care of pre-trial. And the court would always just announce which expert voice was reliable and therefore, impose that as an instruction on the jury. But in the ordinary case, of course, both a defendant and a plaintiff would be entitled to put forth expert testimony. The plaintiff, again, has the burden to show to a reasonable degree of medical probability that this is the cause of plaintiff's injury more likely than not. Although the defendant can do that, he's not required, he or she's not required to do that. And in this case, we have Dr. Tenner that did consider plaintiff's real water theory, that real water caused injury, and he rejected that theory. So the fact that he rejected that theory, I think, was part of the confusion, because in some deposition questions, he was asked, did you consider real water as a cause of plaintiff's injury? And he said, no, I didn't consider that to be plaintiff's cause of injury. But what he means by that is he considered it and he rejected it. So we have, for example, on page 5 of this expert report where he's talking about Richard Belsky. And he says that he explains talking about acute hepatitis C and his explaining his gastrointestinal symptoms. And then he says that he mentions the time delay, right? Mr. Belsky did not recall consuming real water within 30 days of his symptom onset, which would make a toxic effect from the water highly unlikely. So he does consider it. He considers real water, but he considers it to be highly unlikely. It's like the example at the end of Williams versus District Court, where you've got alternative causes A, B, C, and D, right? And if each of those is equally likely, that doesn't make the opinion unreliable simply because the expert can't pinpoint which of those causes was more likely than not to be the plaintiff's injury. The expert is simply pointing out the sort of the idiopathic nature of that particular injury. But alternatively, we do have Dr. Tenner using his scientific expertise to show that the etiology, for example, of Gallagher, there's etiology of a viral infection as opposed to a toxic contaminant. So if we need to get there, I do think that he does go into the third category of providing an alternative causation theory, and it wouldn't be necessary in establishing alternative causation.
Don't you have to have objective evidence of the alternative causation theories? Just can't make it
You
up.
have to give the performance differential diagnosis. I would agree with that. But my understanding, my reading of his testimony is that he ruled
For
out.
example, if a doctor is going to opine that this cervical problem was pre-existing, there has to be evidence of it being pre-existing. You just can't say, well, I think it's pre-existing.
I don't disagree with that, Your Honor, and I'll move on from there just to say that Dr. Tenner did, in fact, provide an alternative causation theory of viral infection, and that otherwise his opinion should be admissible under Williams under the second category because he did consider but reject plaintiff's causation theory, and he did not need to state an alternative opinion to greater than 50% likelihood.
If he gives an independent alternative causation theory, he has to opine to a reasonable degree of professional likelihood, more likely true than not.
Sure, I agree with that.
Yeah.
Right. And it's different, of course, for different plaintiffs, but in each case, he does consider real water, and he contradicts the testimony of plaintiffs' experts. Let me move on to Dr. Hull.
So if he considered real water under Williams, is he required to accept real water as a plausibility, but then offer up another one at less than 50%? However, there has to be a foundation for it, because isn't that really and truly all plausibility theory is about? You can accept this, but you still have to accept plaintiff's theory, but it could be this. And you know what? There's a foundation for this.
And I think that'll be an interesting question.
But isn't that what Williams says?
I don't think Williams says that you have.
I think it does under plausibility theory.
I don't think the defendant's expert has to agree with the plaintiff's theory being plausible, right? Just because the plaintiff's expert says that it's plausible doesn't mean that the defense.
No, the plaintiff's expert isn't going to say it's plausible. If he better testify to a reasonable degree of medical probability that this is the cause, more likely to be true than not. And maybe I'm missing something, but when I read Williams, and I've read it many times, when it comes to plausibility theory, you got to accept plaintiff's theory. You can offer up another theory, and it has to be a foundation for that. And under those circumstances, you don't have to opine to a reasonable degree of medical probability.
I think I agreed with everything you said, except for the defendant's expert having to agree, or I'm sorry, not if the plaintiff's expert says it's more likely than not, the defendant has to at least agree that the plaintiff's theory is plausible. I don't think that Williams says that. Okay, we will see. Dr. Hull. Okay, so in this case, Dr. Hull, I think, is fairly simple. We're just talking about the requirements for initial experts versus rebuttal experts. There's nothing in 16.1 that requires that limits a rebuttal expert simply because that same expert has also testified as an initial expert, so long as the rebuttal report responds to the experts put forth by the plaintiff. And in this case, Dr. Hull did respond to the plaintiff's experts on each of their experts' opinion, both generally and also with respect to each of the individual plaintiffs. Again, remember that defendants don't have to produce initial expert reports, right? We could rely just on the plaintiffs producing their initial experts, and we could only rely on rebuttal experts. In this case, Dr. Hull did happen to produce an initial expert report, but that doesn't make his rebuttal report any less responsive to the opinions by plaintiffs. Again, plaintiffs focus in their opposition about Dr. Hull adopting, in some cases, the opinions of Dr. Dara, who was excluded. But that is far from the entirety of Dr. Hull's opinion. He doesn't merely parrot Dr. Dara. He talks specifically, he draws his own conclusions, he relies on other experts, and he specifically says that, again, like Dr. Tenner, that real water is not the cause of liver failure. This is in relation to Mr. Belsky. Let me make sure I've not missed anything on my notes with respect to Dr. Hull. Oh, and then, actually, here's another example with Miss Ryerson. This again, it's not adopting opinions by Dr. Dar or anybody else that was excluded, but Dr. Hull on his own also states that he believes that the Miss Ryerson's death was not caused by real water, but he talks about the obstruction, the obstruction of her bile ducts. So again, although there are limits to initial expert reports, there are limits to rebuttal expert reports. Dr. Hull testified squarely within the limits of proper limits of a rebuttal expert, and his opinion should not have been excluded.
Okay, here's my question for you. Is this true or not? If the defense expert does not consider the plaintiff's theory of causation at all, then the defense expert must state any independent alternative causes to a reasonable degree of medical probability, because he or she then bears the burden of establishing the causative fact for the trier fact, period.
Agree 100%.
Okay.
Yeah, and the only thing that I don't see in that sentence is anything about the expert having to consider the plaintiff's theory of causation as a plausible cause.
I mean, that's in the case. They talk about plausibility there.
Okay.
Right? That's all they do. In fact, I'm just paraphrasing, but I thought the Supreme Court said, well, if you're going to opine less than to a reasonable degree of medical probability, because it makes perfect sense. You got to accept plaintiff's theory as one of the causes, but you offer up an alternative cause. It makes perfect sense. I mean, it really and truly does. Because if that's the case, then you could just throw speculation up against the wall and not support it by competent medical evidence, right? That's been tested to a reasonable degree of medical probability and all those wonderful things.
I think our record is pretty clear, so I don't need to go on and on about this.
Okay.
I do think that
One more time.
Well, I do. I think that it is within an expert's purview, even an expert that is called only to contradict the plaintiff's theory, to point out the flaws in the plaintiff's expert's methodology, which would include failures in the plaintiff's expert's differential diagnosis. And the fact that a plaintiff does not consider particular etiologies of a disease renders that plaintiff's expert's opinion suspect, or renders any expert opinion suspect. If in performing a differential diagnosis, they don't account for possible causes.
But I mean, that's what doctors do all the time. Every time someone walks into a medical office, they perform differential diagnosis. They consider a lot of different issues. That's what they do.
Right. And for Mr. Hugh, for example, right, there would have been a proper differential diagnosis would have considered alcohol consumption as a possible cause.
And that's something that would come in, but my point is this, you have to have a medical foundation for it. You just can't speculate and throw stuff up against the wall. That's what used to happen. Just throw it up against the wall and the trial judges will let it happen. And then Hallmark comes down and the Nevada Supreme Court reminds us, you know what? Trial judges, you're the gatekeepers. Follow Daubert. Right, Mr. Polsenberg?
Well, not quite, Dalbert.
Oh, no, I know it's a different standard, but as far as they got the gatekeeping language from where?
Exactly.
That's my point.
And I certainly don't mean to diminish the court's gatekeeping.
No, you're not. We're just enjoying the discussion. That's
I'll
all.
obey your honor.
We're just enjoying the discussion. That's all.
All right, since this does not have as many interesting legal issues, I think I'll rest on our briefs on the testimony from Mr. Hudson about Mr. Gallagher. I realize Mr. Gallagher is not an adult yet, but Mr. Gallagher being on the 2020 airlift flights to Utah. But I think we'll just rest on our briefs for that. Now I want to turn to Dr. Babcock. So Dr. Babcock's another interesting situation where you have expert testimony, and Dr. Babcock says, "Look, I looked at these 15 meters, and here are the conclusions that I draw from testing these meters." Plaintiffs have every right to say, "Look, here's why that testing was flawed." In fact, we see that all the time in trials, right? One expert conducts testing, the other expert says, "No, here are the problems in that expert's testimony." But it wasn't. I think it went beyond the court's gatekeeping function to actually say that testing was so unreliable that it couldn't go in front of the jury at all. We get the statements about, hey, look at the photographs of these meters versus the original meters that were actually used in the real water facility. Dr. Babcock.
Is this the situation where we had a different color meters?
It is, Your Honor. Yes, we had the different covers. And Mr. Babcock testified that this, or in his report, he talks about the differences between those meters. But the point is that he didn't find those differences, such as the color of the cover, to be material. And as everybody knows, because the issue of how long these meters last was an issue at trial, these meters were designed only to last for 6 months. And so it would have been impossible to test the actual meters from real water by the time we were into discovery and naming experts. So he was doing the best testing available with the meters that were available to him at that time, which were going to be more accurate than testing dried out meters from years before. I understand that plaintiffs have objections to certain aspects of how he conducted that testing, and even to the similarities between the meters and differences from the year of manufacture. But again, those differences were not material, and at least Dr. Babcock testified that they were not material. I think it would have been up to the jury to weigh that testing. So it was inappropriate to take that issue away from the jury just because plaintiffs opined that the meters were, in fact, that they had the different outer casing. I think that's all I need to say about Dr. Babcock. Okay, the summary judgment on.
Here's my question as far as Babcock's concerned. Is it true that he didn't even compare meter serial numbers and probe numbers to determine whether or not those meters were actually MW500s? Those are the very foundation.
My understanding is that he did establish that they were MW500 meters. I'd be happy to have somebody correct me if I'm wrong about that. I don't think that the serial numbers would have tracked. It wouldn't have shown simply by examining the serial numbers whether this was in fact an MW500. but I don't recall plaintiffs saying that these were not MW 500 meters. I believe they said that the probes had changed. But again, I think that's a jury question as to whether any differences in the probes, which I don't recall hearing about those specific differences, but whether those differences in the probes would make the testing so unreliable that we shouldn't accept it. And again, this was critical evidence for our defense because.
But what about this? I mean, this is actual testimony. And I think this comes out of Babcock's depot. Question. And this would be volume 1, lines 93. I'm sorry, pages 93, lines 3. I think it was a little, I'm going towards the end to page 94, line 15. But here's the question. The Milwaukee 500 meters that were actually used by Real Water to manufacture its product, did you determine whether they were manufactured at a different time than any other Milwaukee test meters that's used? Answer. I don't know when those meters, like the one shown in the exhibit, I don't know exactly when those were manufactured. Question. Did you do any comparison of the actual meters used and the test meters? No. Did you do any comparison of the probe styles? Answer. No.
So, Your Honor, and if there were evidence that in fact the probe styles were markedly different, materially different, if the manufacturing process had significantly changed from when the meters used in Real Water's facilities had changed, was different from the meters used at the time of Dr. Babcock's testing, then I might agree that there would be a point set, but it wasn't.
Is that the defense expert's burden to do that from a foundational perspective? Here's my point. Like, say you had a blowout, right? And there were issues regarding the manufacturing defect of a specific tire, right? And I won't mention the name of any major automotive tire manufacturers, but and they had a specific line, and they went out and did some testing. It wasn't the same tires. How would that be, Jermaine?
Well, I don't know the answer because I'm not a tire expert, Your Honor.
But I mean, it really focuses on being the appropriate foundation for any expert opinion. You got to test the same stuff, you know? I mean, doesn't matter whether it's a coefficient of friction on a walkway surface. You got to, or it's tile, ASTM standards. I mean, it has to be the same stuff, right?
I would respectfully disagree that in every case it has to be the exact same material or the exact same time of manufacture or anything like that. I agree that
why would you object to that? I mean, I would hope if you're going to do testing on tires, it would be the same manufacturer and the same brand and the same possible lot number and all those things.
Well, the answer again is I don't know because I think that's a subject for expert testimony, but I could speculate.
But that's one of the reasons why they attacked the expert's testimony. It went to the foundation, right?
I don't think counsel can attack experts' testimony on that basis. I think another expert.
They did.
Well, Your Honor, so let me take your example of the tires, which again, I'm going to confess I don't know very much about tires. Well, let's say these were 50-year-old tires that are no longer manufactured, right? And you're talking about, sorry, that's a bad example, but an accident, let's say an accident that happened many years ago. Right, you're doing testing for an accident that happened many years ago, but the tires at the time of the accident were relatively new. But over time, exposure to the elements, et cetera, the tire degrades. And at the time of testing, if you took tires from that time period, they would now be older tires, and they wouldn't necessarily be. That testing would not be reliable if you're going back to the exact same tires because of the passage of time. I don't know that that's the case because again, I'm not a tire expert. But in the case of these,
I can answer the question for you without going into the tire example, because at the end of the day, we're talking about meeting the assistance requirement under Hallmark, right? It has to be same or substantially similar. It has to be the same product or the same
Same design.
Well, this isn't a design defect case necessarily. I mean, I thought it was a warnings case. But my point is this, you have to compare apples to apples. That's probably the best way I can say it, right? You can't compare apples to oranges.
Right, and I do believe Dr. Babcock did the very best he could about finding similar apples. So to the extent there were differences, again, plaintiffs can point that out, but I don't think that the differences were so material that they rendered his testimony as a whole unreliable, such that he should have been stricken from the jury. And again, this is a case where we're limited in our ability to prove a defense. But one of the defenses that we can raise is on causation. So it's critical that we be able to establish that, look, even if plaintiffs had not soaked the meter in
Conditioned.
for 45 days.
Condition, wasn't that determined by conditioning? Okay.
Right. That nonetheless, the meter would still achieve negative RP readings. So I think this should have been an issue. It's an issue of weight that goes to the jury. It's not something that is within the court's gatekeeping function to exclude simply because the same style and the same style of meter was manufactured at a different time. Okay, I will be brief with the next one. I know I keep saying I'm being brief and then not always being so brief.
You're right.
On the breach of an implied warranty for fitness for a particular purpose. Again, we disagree with the court's grant of summary judgment on that. Ewing versus Critical Radovan talks about how a claim can be tried by consent of the parties. And one of the points that it makes is that it's difficult to do that when the evidence that's presented for one claim is also relevant to another issue in the case. And that's what we have here. The evidence that plaintiffs put on for their unpleaded breach of warranty case was the same evidence that was relevant to their product's liability claim. So and
didn't we have a discussion about that on the record and how I discussed the origin of strict products liability stemmed from the implied warranty type stuff? Didn't we have that?
That's absolutely right. So, which makes it all the more important for plaintiffs to be clear in their pleadings, as they have been in other cases in this litigation, to be absolutely clear about what claims they're bringing against a manufacturer or product. Because you're right, that products liability did spring out of the warranty
area.
case. Right.
Yeah, I remember that.
So I don't think that we were on notice of an unpleaded warranty claim when plaintiffs expressly pleaded claims of strict products liability. I will move on from that. Well, actually, the next part that has to do with the same evolution of the law in products liability. As you know, warranty was eventually subsumed into products liability. And as a result, we have an interesting situation where the Nevada Supreme Court eventually adopts the restatement second 402A as sort of a guidepost for products liability in Nevada. It's interesting if you look at the restatement.
402A,
Yes,
and they rejected 402A
they rejected
third.
They rejected the third restatement.
Yes,
Correct.
right.
Yeah, Ford versus Trail, absolutely. And so this gets to my argument on apportionment of fault. So in the ordinary case, you have one product, and you have maybe one defendant or multiple defendants, but each of those defendants is in the same chain of commerce, the same chain of manufacture, distribution, and retail to an end user. But here you have two products. You have the real water product and you have the meter product. And the meter product at no point comes in contact with the plaintiff, right? Part of the trade-off, the policy trade-off that the legislature and the courts in developing products liability through common law that they made is that, look, if you as a plaintiff don't have access to all of the information that a product manufacturer does, but you are directly injured by that product as a user, and possibly, although it's not been definitively addressed in Nevada as bystander, there's a degree of fairness in holding the manufacturer or the distributor or the retailer strictly liable, even though negligence is always available to a plaintiff as a theory. But that ability to bring strict liability is dependent on the plaintiff's proximity to the product that is defective. So if a car crashes into a plaintiff, or if a car that a plaintiff isn't using, shrapnel from the crash injures a plaintiff, and the plaintiff is directly impacted by the product, comes into direct contact with the product, then it's conceivable at least that the plaintiff could in Nevada have a claim for strict liability for that product. But here you have two different products, and the plaintiff only came into contact with the real water. In that situation, as Mr. Polsenberg was talking about earlier, the plaintiffs still have their claim for negligence if they had chosen to assert one, which they did not. But the law does not expand to allow plaintiffs to bring products claims when they're not an end user or a bystander directly in contacting the product.
But why aren't they the end user in this case? Because they actually are the consumer of water. And the ORT meters were part of the manufacturing process used by Real Water to manufacture this alkaline water.
But they weren't a component part, right? The meters were never incorporated into the product that made it to the plaintiff.
Well, when you say component part, I mean, there's different types of products, right? There's some products that are consumed. It can be apples, oranges, water, or whatever. We're not talking about a failed electrical brake system on an automobile, right? This is a little bit different. But it's my recollection that the ORT meters were actually used as part of the manufacturing process by Real Water, right? And they relied upon that. And the sole issue really focused on one specific area, and it's regarding the use and instructions of the ORT meters. And and it's my recollection, you had the insert and then you had the card, something like that. And the plaintiff's experts said, look, there should have been better instructions to the end user how to use this product, right? And I think there was some issues regarding, well, isn't that outside of the carton good enough? Is the card good enough? Because clearly the instructions were inadequate. That's my recollection. Right?
All of those claims would be claims for Real Water as the end user of the meter to bring in, say, an indemnity claim. But they're not claims that belong to the plaintiff in strict liability, right? Negligence can be broader. You know, the Paulsgraf case where box of fireworks on the train, so the passenger drops the box of fireworks, they explode, and then scales over on the other side of the rail, the train station, break and fall on Miss Paulgraf's head, right? There is not contact with the initial fireworks, but there is perhaps a negligence claim, perhaps, although Chief Judge Cardozo didn't think so because it limits approximate cost. But in negligence, you can reach farther.
But we're talking about strict products liability.
Exactly
The
right.
thrust and focus in a strict products liability is on a product.
And all I'm trying to do is differentiate between the two products, because the one product, Real Water's product, did make it to the plaintiffs. The meter never contacted, never made it to the plaintiffs. It was never incorporated into the product. It wasn't a component part of Real Water.
Why wasn't it incorporated into the product when it was used in the manufacturing process, right?
All sorts of products are used in manufacturing, right? You may have.
And if the product ultimately ends up being defective, they can potentially be on the hook under 402A.
If the product.
The second restatement, not the third, the second.
I agree with that, Your Honor.
Consumer expectation test, right?
Yeah, but if you have say a steel cutting machine in an auto factory, right? That steel cutting machine does not, in fact, become incorporated into the product. The claim that the plaintiff had would be against the auto manufacturer, wouldn't be against the manufacturer of the steel cutting machine, unless the plaintiff were able to prove something like negligence, but strict products liability, no. Regardless, even assuming that there is two.
So if you had in a quote motor vehicle and for whatever reason there was a defect in the software and the brakes failed, you're saying that under those circumstances the plaintiff would be limited to suing the auto manufacturer, and they couldn't sue the entity responsible for the malfunction itself.
I may have misheard your hypothetical. Is this software that's actually in the?
Or software in the car, or a brake component, or any component in the car.
Well, if it's actually a component of the car, then of course it becomes incorporated into the product. Plaintiff interacts with it directly, and yeah, that would be ordinary products liability. But if we're talking about the software that the car design people use, and it's software that never makes it to the plaintiff, the claim would be again against the car manufacturer. If there's any claim against the car design software, that would be a negligence.
That's probably not a good example, because you have defective design, but I understand what you're saying, sir. I did.
All right, let me get directly to the apportionment issue. Plaintiffs, and we have a disagreement about 41.141. Again, this is probably a disagreement that Dan and Mr. Polsenberg and Mr. Kemp have had back to the 80s, and you've been involved in that in many cases as well.
He's younger than Will.
Oh, okay. But specifically subsection 5, which was not.
You're in the 80s, Mr. Posenberg.
But you're still younger than Will. You're.
I don't know. We might be the same age.
Cheap shots.
I think the parties agree that the applicable exception, if there were any, would be subsection 5E. Which I apologize, I had this on my screen when I. Of course, moved it. All right, which says. This section does not affect the joint and several liability if any of the defendants in an action based upon E, an injury to any person or property resulting from a product which is manufactured, distributed, sold, or used in this state. And Cafe Moto, I think, is helpful here because for two reasons. One, it talks about the difference between the claims that a plaintiff may have against one defendant versus a different defendant, but it also talks about the meaning of the word action. And action in the context of 41.141 means the action that the plaintiff has against that defendant. So an action in this context, in effect, means a claim. Here, there are two different actions. The action against Real Water is an action for defective water. The action against Milwaukee is an action for a defective meter, but they're two different products. So the strict liability that attaches to the water is separate from any strict liability that would attach to the meter itself. There's nothing in the text of 41.141 subsection 5 that suggests that two different products that each cause or contribute to a plaintiff's injury would be jointly and severally liable. And I think in this situation, the court should separate the two products, and the jury should have been able to separate those two products to say to what degree was the injury attributable to this product, even if everybody in the chain of commerce related to that product would be strictly jointly and severally liable, as compared to injuries caused separately by the Milwaukee meter. And everybody in the Milwaukee chain of commerce would be jointly and severally liable. But those two spheres don't merge together. The two products remain separate products, and you can't attribute the joint and several liability for the water over to the meter, which is a separate product. My last point is just on the this is on the sanction issue that we were just talking about before. Again, we do join we join Hanna's argument with respect to the need for an evidentiary hearing. And again, this is sort of the reverse of like a Paul versus Poole or Pierce versus Gerhardt versus Pierce Enterprises situation, where the Supreme Court has told us that if you have a defaulting defendant and a non-defaulting defendant, the defaulting defendant still gets to rely on the answer of the non-defaulting defendant, because any defenses common to the two would inure to the benefit of the other, notwithstanding the default. Here, we're in the position of the non-defaulting defendant because the sanction was not assessed against Milwaukee. But the sanction that was assessed against Hanna had the effect of sanctioning Milwaukee as well. And that's where the prejudice comes in, because the plaintiffs are right that this is the appellate lawyers missing some of the details. They point out that this was the same product. This was the same product. And as a sanction against Hanna, the jury was told that this was a defective product. So how, of course, how could the jury have found them different against Milwaukee? It decided the case against them. This was an issue that could have been assessed after trial. If the jury, based on the jury's verdict, the sanction, if there needed to be a sanction, could have been assessed against Hanna at that time. But telling the jury that as to Hanna, this product, which is the same product, is defective, and that Hanna is liable, had the effect of striking Milwaukee's answer when there wasn't a basis to do so. So with that, Your Honor, we would ask you for a new trial. If you have any other questions, I'll sit down.
None at this time, so thank you. So Kemp.
Your Honor, starting where they started. They started with the email on March 19th, 2019. First of all, there were two emails. So what happened in this case is they did their 16-1 production. We took the deposition of Jason Brown. During Mr. Brown's deposition, we asked him about the first email. The first email was also dated March 19, 2019. Someone, and to this day, we don't know who did this, someone whited out the body of that email. The body of that email says something to the effect of, hey, we're having problems with the meter. How do you calibrate it? And they whited it out to conceal the fact that Real Water had reached out to Milwaukee and asked for direction with regards to how to use the meter. So that was the first email. And that wasn't produced until the deposition. Live in the deposition, Mr. Brown went onto his computer, found that email, read it into the record, and it was pretty astounding. So what we did after that is we sent discovery requests asking, well, how did this happen? Who was the one who whited out this email? Who whited out the body of the email? Was it counsel? Was it the client? And the best answer we got was Mr. Brown said that Mr. Savaggio handled the production. He said that during his deposition. That was the only answer we got, because when they responded to the discovery, they ducked any meaningful response to explain what occurred. So after that happened, we filed a motion for default because they had not produced this at 16-1 or in response to request for production. So that was the motion for default. Mr. Smith says, well, the plaintiff should have filed a motion for default. We did file a motion for default. And in response to that motion for default, they said, oh, don't strike our answer because we have now produced all the March 19th, 2019 email chain between Jason Brown and Michael Bush. We produced it all. They said that in their opposition. Okay. After that happened, they produced this email, this second email, which is the one Mr. Smith is talking about. And this was produced on May 19th, 2023, over 4 years after it was sent. Again, no explanation as to who whited out all the materials in the first email. No explanation as to why they lied to the court and said they produced everything. And 2 months later, they produced this new email. Nothing whatsoever. And then they come to court and they say, oh, well, we should be able to use this email and we should be able to present Mr. Brown's testimony. If the court recalls, over our objection, the court granted Milwaukee's request to present Mr. Brown live by Zoom. Mr. Brown apparently has some medical problem that lasts years. But in any event, the court, I thought, was very gracious. And it was over our objection. They allowed Mr. Brown to testify. Ultimately, they decided not to present that testimony. So now we get to this email. And under these circumstances, the court was proper not to allow that email in. Again, it wasn't produced in 16-1. It wasn't produced in response to the request for production. We filed a motion for default. In the opposition, they said they've produced everything. They refused to say who whited out the first email. And then this new email magically appears. And to this day, we don't have any foundation for it. So for those reasons, Your Honor, we think the court's ruling was appropriate on that point. They say, oh, well, all this is excusable because Mr. Brown was sick. Well, in this 2-year time period, they couldn't have someone go through the computers at Milwaukee and look for the emails, especially after saying in the opposition to the motion for default that we produced everything. So that excuse I don't think is credible. So with regards to that, we think that really they got away with something there because they were still allowed to present Mr. Brown's testimony, and they decided not to do it. Second thing they argue about is this stipulation of real water as to liability. Well, Your Honor, this is kind of funny because here, Milwaukee, which is insured by Liberty, Real Water, which is also insured by Liberty, Milwaukee is accusing Real Water of colluding with the plaintiffs to enhance the liability of Milwaukee, their other Liberty insured. Without one shred of evidence, they say in this motion, quote, the stipulation was clearly collusive, aimed at increasing the liability and damages against Milwaukee. That's the accusation they make without one shred of evidence that another counsel employed by the exact same insurance company is colluding with the plaintiffs to do Milwaukee in. Your Honor, that is just so preposterous that I don't even know how to respond to it. But the stipulation was not collusive. It was done by Real Water for a good reason. They wanted to try to minimize the compensatory damages, and I think they did a good job of that because they didn't want the jury to think that they were making a frivolous defense. And a defendant can always.
This is important too. I think Mr. Odou did a very good job of this at trial. He didn't want to offend the jury.
He didn't want to offend the jury. He wanted to tell the jury. And how many times did he say it? Every time a plaintiff came out, he said, we're sorry for what happened. We accept responsibility. How bad are you hurt? That was pretty much his defense in the trial.
And this is important. That's the duty and obligation he owed to his clients.
And
right?
my argument would be that stipulation actually helped Milwaukee because it reduced the overall compensatory award. Remember, there weren't separate compensatory awards, one against Real Water and one against Milwaukee. It was all the same thing. So I would submit that if anything, they were helped by this stipulation.
It could really be argued because I would anticipate that Mr. Odou would have taken a very aggressive stance that we did nothing wrong and this and that. It might have been a double.
Yeah, so for
the verdict.
Yeah, in any event, they say it plainly impacted Milwaukee. Well, any impact was in favor of Milwaukee, not adverse to Milwaukee, in my view. Okay, but if they thought that there was some potential problem with Real Water stipulating the liability, they should ask for a curative instruction or some sort of instruction to the jury. They didn't ask for anything, Your Honor. So for those reasons, I think that argument doesn't have merit. Now let's talk to what they refer to as, quote, false testimony by Dr. Hudson. Well, what happened here is they were talking about the 5 babies, and Mr. Parker misspoke and asked Dr. Hudson if plaintiff Gallagher was one of the 5 2020 babies. And right as soon as that happened, Mr. Parker went up and corrected it. He asked Mr. Hudson on the record, oh no, Mr. Gallagher was really, or baby Gallagher, I'll call him, was really 2019. So, and nothing happened. They didn't ask any follow-up questions. There was no objection made. There was no discussion whatsoever. So appellate counsel has poured over this record, and now there's all of a sudden some sort of Leochi violation that Mr. Parker has committed. Your Honor, first of all, it was corrected immediately. Second of all, the MMWR, which was a stipulated exhibit, stipulated to both by Milwaukee and by Real Water, specifically says that those 5 babies were transported in 2020. I addressed that during my opening statement. I think it was referred to by other people during the trial numerous times. So to suggest that there was some sort of attempts to inflate the baby Gallagher damages by comparing them to the other 5 babies, there's no support for that. And I'd also point out that baby Gallagher was the worst baby in terms of his condition. If you recall, baby Gallagher was number 1 in the entire United States on the liver transplant list.
And the
Right.
physician instinctively said, let's wait 24 hours.
Right. So the other 5 babies were in bad condition too, but there was no attempt being made there. They call it, quote, intentional gamesmanship, unquote. But there was no attempt to equate Gallagher with those other 5 babies to enhance the potential damages for the Gallagher baby. So that argument, I think, is inappropriate too.
Mm-hmm.
Now let's turn to the expert testimony. Okay. They talk about 3 different experts, Dr. Tanner, Dr. Hull, and Dr. Babcock. All of them are a little bit different. So let's start with Dr. Tanner. They start out by saying, and Your Honor, I think what you said is exactly right. Throw it up against the wall. Every 15 years, at least that's been the record so far, we have to go up to the Nevada Supreme Court and we have to get this clarified. First it was Morsicata, and then approximately 12, 15 years later, we have to do Williams. Williams is a 2011 decision. So it's about time to go back up there again and reaffirm the principles. But the basic problem here is that these defense attorneys just like throwing things up against the wall. They're in love with spaghetti, okay? They just want to throw it against the wall and see if the substance sticks. And that is not what's allowed under Morsicata and or Williams. And that's what they were trying to do with Dr. Tanner, excuse me. So Dr. Tanner, they start out by saying, Judge, Dr. Tanner considered plaintiff's causation theory. Well, here's the testimony from Dr. Tanner. Question, and this is on page 13 and 14 of our opposition. Question, so backing up a little bit, when you issued your first report, hydrazine was not one of the possible causes you looked at, correct? Answer, correct. Didn't look at that cause. Gets worse. Question, okay, so prior to April 25th, and I'm choosing that date because it's the day after your April 24th report, which was the second report. Prior to April 25th, you did not consider the water as an alternative cause. Is that correct? Answer, correct. That brings us squarely within the holding of Williams that Your Honor asked counsel the question about. And again, quote, if the defense expert does not consider the plaintiff's theory of causation at all, then the defense expert must state any opinion alternative causes to a reasonable degree of medical probability. And it continues. So just those 2 quotes alone show you that he did not consider the plaintiff's theory of causation. So that meant that Dr. Tanner was required, if he had an alternative cause, to present it under the probability standard. He couldn't do so. We asked him what his testimony was, and in his answer, he says it could have been this, it could have been that, it could have been this, it could have been that. It was spaghetti against the wall. That's exactly what he was trying to do, and that's why the court was correct to exclude his testimony. And it got so bad that he couldn't even tell me the name of the virus, dozens of viruses, hundreds of viruses, any evidence in support of any specific virus in any specific plaintiff case. Nothing, just could have been, could have been, could have been, could have been. And that's why it was properly excluded. That's Dr. Tanner. Now let's move to Dr. Hull. Dr. Hull is a little different. Dr. Hull is primarily an epidemiologist. He does have a medical degree, but Dr. Hull did not include one single causation opinion in his original report. Nothing, absolutely none. He stuck to epidemiology. In his reply report, he read Dr. Dara's opinion in her initial report about turmeric painting and kratom with regards to Mr. Haley and Mr. Belsky. And he liked it. So he says, quote, I concur, unquote, with Dr. Dara's opinion. This is the opinion that they're asking the court to have allowed. Well, the problem is we filed 3 different motions in limine with regards to turmeric, house painting, and kratom, pointing out that there was not one shred of science in support of this. They backed off the painting. They pulled that one back themselves. But we argued turmeric for Mr. Haley and kratom for Mr. Belsky. And the court ruled that there's no science supporting the causation. And again, that was directed at Dr. Dara, but that same ruling applied to Dr. Hull. I mean, if there's no science for Dr. Dara, how could there possibly be science for the concurrence opinion? So that's why Dr. Hull's opinion was not allowed, and that was proper. Now let's talk about Dr. Babcock. Dr. Babcock, all we're talking about is the testing because he was not totally excluded. And the testing was properly excluded because it's their burden to prove that it is either the same product or substantially similar. That's not my burden. That is their burden to prove that when they're admitting testing. Not only did they not prove that, but Dr. Babcock testified that he did tests on 15 different meters and he didn't like the results on 2 of them. So he just threw those out. He threw them out completely. So he decided himself that over 10% of the meters he tested, for whatever reason, was not substantially similar. Then we got to the questions the court alluded to, which were, did you even compare the meters you tested with the meters being used? Did you look at the serial numbers? Did you look at the probes? And we know from the testimony that the probes changed over time. Yeah, this is their burden. And he responded that he didn't even look at that. So this was a failure on the part of either the proponent of the testing, I think it was Hanna, maybe it was Milwaukee, but it was the proponent of the testing and or the expert had the responsibility to make sure that they were using the same product or at least something that was substantially similar and that they were able to prove that. They couldn't do that, and that's why the opinion wasn't allowed. Moving on. The breach of implied warranty claim. They make it sound like the court entered a full and complete summary judgment on implied warranty, and the only thing we did is we went to the jury on compensatory damages. That is not what happened. We filed a motion for summary judgment on a very limited portion of the implied warranty claim, which was that the one of the particular purposes of the MW500 was to measure alkaline water. That was it. And that was admitted in their product literature. That was admitted by Mr. Brown during his deposition, which was played at trial. We had dozens of emails from different customers saying, can this be used to make Kangen water or alkaline water? And Mr. Brown called it the go-to meter. That was his. He called it the go-to meter to make alkaline water. So there was no really meaningful opposition to that summary judgment motion. And then the other issues, whether it was fit for that particular purpose, causation, that was resolved by the jury. And if the court recalls, we had a specific jury form that had causation as part of the implied warranty finding, because I didn't want to get up on appeal and have Mr. Polsenberg, who's good at, finding a little string that I missed. I didn't want to get up there and have him, a big string. I didn't want to get up there here and have him say, there's no causation finding, or this is wrong or something. So we had a pretty specific causation verdict after a pretty heated debate among plaintiffs' counsel, I might add, because it wasn't requested by defendants, we offered it. So with regards to the implied warranty, we think that was 100% proper and it was properly resolved by the jury. They argued the motion that there was a runaway compensatory verdict. I'll rely on our opposition on that because they didn't address it during oral argument. We've already talked about the set off. The apportionment of liability. This is an interesting issue because Cafe Moda, we really have 2 products here that are being sued under a strict liability theory. So our position is that it's covered under, I believe, the fifth exception, that's strict liability. I think you have to do it that way. If it was a case where, let's say we have the exact same product, the meter, and we were suing under a negligence theory and not a strict liability theory, I think they may have a better argument than they have now. But when you have strict liability, two different products, I think you've got to be covered by the language strict liability in 41.1415. And so for that reason, we don't think that there's any apportionment by the jury. This may be something that they can talk about in contribution or indemnity argument, but the jury, I don't think it should be resolved by the jury. And remember, the jury was instructed that it has to be a substantial factor. So the jury had to make a determination that both products, product one being real water and product two being the meter, were a substantial factor. The failure to warn was a substantial factor. The implied warranty was a substantial factor. And now moving over to this, it's kind of a bicycle, Mr. Smith ran to Paul's draft and talked about that. I read a real interesting case about an article about how Paul's draft was all wrong factually. They went through what really happened that day. But in any event, Paul's graph really comes down to foreseeability. So I think the touchstone here really is foreseeability. Is it foreseeable that if you have a measuring device that's used in a manufacturing process or even a storage process, is it foreseeable that if that manufacturing device malfunctions, that it can hurt somebody? And if so, they should be liable. And I think that's what it comes down to. We cited, the bystander cases. Chiavani is probably the classic bystander case at this point. But we also cited a Nebraska case, which discusses this issue, kind of gets right into it, about two different products. And basically it says what I said, that, it's really a foreseeability test. And so I think this is going to be a good issue to tee up for the Supreme Court. I think they're probably going to give us clarification on it. But I don't think you can say that it is not foreseeable that when you have a measuring device that's like a thermometer that you use for children or anything, the meter here, a measuring device that's used in the manufacturing process, I don't think you can say, especially in a food context, and food includes water, I don't think you can say that you can't foresee that a defect in your product won't potentially cause injury, cause harm to a consumer. And not only can you foresee that, but if you recall, we had a piece of product literature that expressly said that you should use the MW500 for alkaline water because it can help prevent harm that could otherwise be done by the inferior product. So foreseeability is the touchstone, and that's why I think the bystander rule should be extended in this case. Last thing, they talked about the Hanna sanctions. Again, they didn't offer a curative instruction, and I think there's an argument to be made that the sanctions actually helped Milwaukee because, in a way, Hanna was conceding liability like Real Water did. At least that was the way they played it, and I think that might have helped keep the verdict down. So it might have actually helped Milwaukee. But in any event, if they thought they were being prejudiced, ask for a jury instruction. In the motion, they argue that the court should have sua sponte severed the case last minute. I don't know if they meant that they should have just got out and started over again, or whether we should have had jury deliberations or what. But they didn't file a motion for severance. If they thought should have been a severance, they should have filed a motion. In any event, for all those reasons, we think that the motion for new trial should be denied. If the court has any questions, I'd be happy to answer them. Otherwise, I think I've covered most of the points.
Not at this time, sir.
Thank you.
Your Honor, you want to take a break?
If you need a break, Mr. Polsenberg, we'll accommodate.
Thank you, Your Honor.
We'll go back on the afterwards. Sir, you have the floor.
Thank you, Your Honor, and I will try to be quick. All right, so let's start with the emails. Just as since Mr. Kemp brought up the issue of the motion to strike, just to set this in sort of context. Initially, plaintiffs did file the motion to strike. Then after the initial hearing, but before the court ruled on the motion, there was a supplement in July of 2023. In which case they brought up the email in that supplement. So they had awareness of that email, but the motion was denied. And we as a result believe that the email had not been excluded. Court didn't issue any alternative sanctions excluding the email. And we did produce, we said we'd produced everything that was discussed in the Rule 37 letter because that was related to the request for production and was the subject of the motion for the motion to strike. And that part was true, even though the email, which was not an obligation under Rule 34, but was our 16.1 obligation, had not been discussed. So just to put that timeline in perspective, that's why when we went to trial, we were under the impression that the email would still be admissible save for any evidentiary objections, but not on the basis of late disclosure. On the stipulation, Mr. Kemp brings up the fact that, well, perhaps Milwaukee did this, or I'm sorry, perhaps Real Water did this because it would make the jury happy and award lower compensatory damages. And then they say the same thing about the Hanna's, the instruction about Hanna's answer or liability defense. Well, we do have the verdict in this case, Your Honor. I think it's a little bit difficult to say that the jury was especially enamored of Real Water given that they awarded $200 million in punitive damages against Real Water. So to say that this stipulation was somehow effective in reducing the compensatory the damages liability is a little bit speculative. Dr. Tenner, Mr. Kemp mentioned a series of questions in his deposition testimony talking about his initial expert report and how the initial expert report supposedly didn't consider the potential etiology of Real Water. But where I was talking about was his rebuttal report, which is responding to plaintiffs, and which is the appropriate method for using option 2 in Williams for rebutting or contradicting the plaintiff's expert. And he obviously did consider plaintiff's theory of causation in his rebuttal report. In addition, even the initial
Shouldn't
report,
that have been in his initial expert report though? Because if he has opinions regarding causation, shouldn't that be in his expert report?
Your Honor, hydrazine was not really understood to be a huge part of this case until the initial disclosures of everyone's expert reports. The only hydrazine that had been mentioned was in the FDA. It wasn't found in water, and it wasn't found in the urine samples until after the GE.
thank you. And beyond that, even in his initial report, this Dr.
And I don't mind telling everyone this. I think I think this is an inherent problem or flaw we have under Rule 16. I don't mind saying that because, and some of you might not know this, but we had more than one version of Rule 16.1. And the initial, and it makes perfect sense under the initial, and I'll call it 16.1.1. And it dealt with experts. Expert disclosures were staggered. Plaintiffs would give their disclosure. I forget what the exact time period was, 60 days later, give or take. Then the defense would give their disclosure. And that's part of their case in chief, right? And it wasn't a rebuttal, but in under most cases, a defense expert can't really opine until they know what the plaintiff's theory will be regarding standard of care breach, causation, and so on and so on. And for whatever reason, our Supreme Court backed away from that, which doesn't make sense to me. It really doesn't. And to be candid with everyone, it makes my job much more difficult. right? Because what's sometimes called a rebuttal isn't a true rebuttal as we know it. And this isn't the problem of counsel in a general sense. It's the way the rules are set. And that's probably
I agree that
somewhere-
the staggering makes sense, and we do have cases even today where the parties will stipulate to a staggered schedule.
But I mean, my point is this, and I get that, and that's the response, but really and truly, why should you have to stipulate?
Yeah.
It should be like that in every case. And it would make my job, trust me, a lot easier, because then I can tell whether something's true rebuttal or not. And that's how it was. And they came out with another version. I think we're at 16.1.3 now. It was something like that.
It's like an iPhone update.
Yeah, I mean, it really is. It just makes my job difficult. It really does. It shouldn't be as difficult.
Yeah, I would say though, Your Honor, that even if you were inclined to strike the initial report because it didn't meet what the alternative causation theory threshold, even so, the rebuttal report, which is a true rebuttal report, should not have been stricken because it did consider plaintiff's theory of causation. And this, I have one last point on Dr. Tenner. Actually, sorry, before I did that, I forgot to mention my previous point. In the initial report, he does say that he considered real water. He says that that none of the above plaintiffs developed liver disease, including hepatitis, end-stage liver disease, nor hepatic failure as a result of consuming real water, even though, as Ms. Lowell pointed out, the issue specifically of hydrazine was not at that point the focus of the case until we got plaintiff's expert report. On the issue of these, to the extent that Your Honor disagrees that Dr. Tenner's rebuttal report meets the requirement of Williams in terms of considering plaintiff's alternative causation theories, it still does meet the standard for a true alternative causation theory because he did say that it was more likely than not that the patient's hepatic injury had a viral etiology. Mr. Kemp says, well, you need to point to the specific virus, but I don't believe that that's the requirement of Williams. If you can point to it being more likely than not a viral etiology, it's not required that you pinpoint this particular virus. But even if you were,
And why would that not be the requirement? Because that goes to the foundation for the very opinion, right? But you can't say, look, well, I think it's this, and but there's no evidence of that, right? And that goes down. I mean, that's ultimately what I talked about at the very beginning. There has to be, if you're going to offer up a true independent alternative causation theory, there has to be a factual basis for that.
and I think there was, but as kind of the reverse of that is the fallback position. It would be, well, it's like the example in Williams of, cause A being 25%, cause B being 25%, cause C being 25%. These individual viruses, even if you were to require them to pinpoint a particular virus, they all share. They would each together be more likely than not, so that the expert could say, look, I can't pinpoint a particular virus, but I do know.
It doesn't have to be a
less
foundation for that specific virus,
Oh, I think the foundation is in Dr. Tenner's report.
right? And but if he offers that up, he has to say that the plaintiff's theory is as likely too, right? That's the plausibility.
That will be the issue that we have to get the Supreme Court to give us guidance on.
But I think it's clear.
Okay.
I do.
All right, Dr. Hull. Again, we heard a lot about Dr. Dara today and how those opinions were excluded, but that was not the entirety of Dr. Hull's rebuttal opinion. He had other opinions, including opinions specific about the cause of Mr. Belsky's injuries, cause of Mr. Hu's injuries, all of the plaintiff's injuries that were not founded solely on adopting Dr. Dara's opinions. And Dr. Hull is clear that he too considered plaintiff's causation theory, and he rejects it. So I don't think his entire rebuttal opinion should have.
So he rejected it, and what did he offer up as independent alternative causation theory?
Well, if he's rejecting plaintiff's theory that he's considering it.
No. It's either a rejection or he's considering it. If he rejected it, what did he offer up as independent alternative causation theory to a reasonable degree of medical probability?
Well, for example, for Miss Ryerson, he talks about the obstruction in the bile duct. That's more likely. That is the most likely source of her sepsis was the obstruction in the bile duct. With Mr. Who, he talks about Mr.
What
Who was
caused the sepsis in the bile duct?
the bile obstruction, the obstruction in her bile ducts. He said it was air, possibly from the radiological exam, but possibly an indication of infection. Either way, it would not have been toxic hydrazine contamination. All right, I just want on the warranty. I get that the scope of the summary judgment wasn't the entirety of the breach of warranty claim, but we still have a 15B issue because the evidence that went to that claim was also relevant to the claims that were presented at trial on the pleaded strict liability claims. So you can't add a warranty claim that's not pleaded if you haven't, if the evidence is the same. An interesting point about foreseeability when we talked about Paul's graph.
Well, here's my question as far as that's concerned, which I think is a unique issue. But what if the same facts support each claim for relief?
I'm sorry, can you say that one more time?
What if the same facts support each claim for relief, i.e. the breach of implied warranty and the defective product?
That's exactly the situation in Hewitt versus Criswell Radovan, where, yeah, you have evidence that supports more than one claim.
Right.
But the plaintiff is the master of his or her complaint. And so if the plaintiff chooses to plead one theory, even though the same facts would support an alternate theory, the plaintiff is limited to the theory that he or she pleads. The whole point of 15.
But can't they move for amend pursuant to Rule 15, right?
They can move to amend pursuant to Rule 15A if they do so timely.
But you can do it during trial too. And then there's an issue regarding consent. And it appeared to me there was consent to the facts that were admitted at the time of trial that supported the implied warranty claim.
It's not consent to the facts, it's consent to the claim. It's consent to the pleading. And we did not consent to this additional unpleaded breach of warranty claim. I agree with Mr. Kemp that
But isn't that something I have to consider? Right? I mean, and I don't mind saying I've had cases where at the time of trial, there's a motion to amend to assert punitive damages, and I had one, and the defense never consented to that. In fact, they defended the case differently, and I denied the motion. In contrast, here, all the evidence came in, and there was no objection.
right, because the objection, I'm sorry, because the evidence went to plaintiff's product liability claim, there would have been no basis to object to evidence that goes to two claims. And if the plaintiff has pleaded one of those claims, there's not a basis to object to it. So it's not trial by consent if the evidence is relevant to two claims, only one of which is pleaded.
So under what circumstances would you grant a motion to amend during trial? Because the rule specifically provides for that.
It does. So if there's evidence that comes in that is only relevant to the unpleaded claim, and that evidence is not objected to, then in that circumstance, if the plaintiff, would be able to make a 15B motion to amend the pleadings to conform to the evidence. Mr. Kemp mentioned, I believe we were talking, this was probably in the context of the apportionment issue, that, foreseeability is the touchstone of a claim. And I agree, it's definitely the touchstone of a negligence claim where foreseeability goes both to the element of duty and to the element of proximate cause. The difference though is in products liability, there's a trade-off, right? That the defendant is held strictly liable, being without evidence of the defendant's state of mind at all, in exchange for the plaintiff having a narrower scope of the claim. And the claim has to be that the plaintiff is injured directly by the product. And if it's a product defendant, then up and down that chain of commerce, each of the participants in that chain of commerce can be liable. But if it's outside that parameter, in other words, if the plaintiff doesn't have contact with the product, then the plaintiff's avenue for recovery would be through an ordinary negligence claim. And then, yes, you would have ordinary principles of foreseeability. I mean, I'd love for foreseeability to be the touchstone here, because as Your Honor just said, you don't expect hydrazine to be in water. We, Milwaukee, did not expect hydrazine to be
But that's not a defense.
That's not what our.
That's not a defense, though. It's not. I mean, you don't expect a lot of things or hazards that happen all the time, right? And that can be the basis of a strict products liability case, focusing on the product itself and or a negligence case, right? A negligence claim.
Well, in a negligence claim, you would consider the foreseeability of injury, if not the particular injury, the mechanism of injury. And here, there's no dispute that our product used to measure.
Yeah, but is this important? Your client knew that what particular purpose that product was being used for, right? That's my recollection. Mr. Kemp brought it up with a little bit more clarity, because it's been a long time and I can't remember the total number of motions in this pretrial motions. How many were there? Yeah, somewhere in that area, but I do remember the discrete motion for summary judgment as to a particular purpose. I remember that because that was a unique motion. I hadn't seen that much.
And without waiving my argument on the warranty claim, right?
That's okay. That's okay.
Even if it were foreseeable that the product would be used in making alkaline water, right? Our product is only used to detect an electrical charge in water. It would not have been foreseeable that our product was used, or that hydrazine, as everybody has said, a dangerous chemical, would be added to the water.
Well, it wasn't really added. I think it was just part of the process.
Well, so again, even less foreseeable in that sort of.
But I mean, I hope we're not conflating foreseeability with duty, right? I mean.
Well, foreseeability is an element of duty.
I get that.
I
get that, but we're talking strict products, right?
Well, that is the question, whether we're in strict products liability or something else. Last point on the jury instruction. Again, I don't see any evidence that the jury was particularly mollified by any stipulation or by the sanction against Hanna. I think instead the jury took both the stipulation and the sanction and punished Milwaukee for it by awarding greater compensatory damages. In response to the argument that we ought to have proposed a jury instruction on a curative instruction, no, the solution would have been not to give instruction 21. If the court had not given instruction 21, which is the instruction we objected to, then the jury would not have heard about the sanction against Hanna. That could have been imposed as a matter of law after trial. Thank you.
All right. Sir, Mr. Reynolds.
Thank you, Your Honor. Just want to note for the record that Hanna did file a timely joinder to Milwaukee's motion for a new trial, in that we concur and agree with the arguments they raised in their motion for new trial, as well as the arguments by Mr. Smith and Mr. Polsenberg, and we preserve those as our own. Thank you.
Okay. Anyway, this is what I'm going to do, and this is regarding, which docket number is it again? 1297 or 99?
1299, and our errata is at 1213. 11.
Oh, okay. Yeah. All right, this is, as far as the Milwaukee Instruments Inc.'s motion for a new trial, I'm gonna deny that. For a lot of specific reasons as it pertains to, I guess, the course of this trial. Number one, I think the record's pretty clear as far as a lot of the evidentiary issues that were decided. Just as important, Milwaukee did play a key role from a product manufacturing perspective in that it knew that its product was being used to for the purpose of production of canned water and or alkaline water. Just as important too, and I think this is really focuses on, I understand now why that specific motion was filed, but it dealt with the sole issue of particular purpose. And this was one of the purposes upon which it was being utilized. Just as important, we have all the issues regarding the adequacy of instructions and those types of things. But I just feel that if there's gonna be a new trial, Supreme Court's gonna have to look at it and make that determination. So when do we come back? And lastly, I don't understand how Mr. Odou's stipulation to responsibility in this case prejudiced any part of it. When do you want to come back, Mr. Polsenberg?
The earliest, I think, I've been corrected by my teammates on volunteering dates that they can't make. So the earliest I think we can come back is the 12th of March.
I like that tie, by the way.
Thank you, Ryan.
I do.
It's unusual to see a purple rep tie.
Yeah, I that's what I noticed that.
Now we'll have to spell rep for the person transcribing.
Can we have 1 second about that?
Yeah, take your time. Yeah, and this is what Tori was telling me. We have two things going on. We have a tort case starting when, Tori?
Our trial starts on the
11th
of March.
March. And we also have a firm setting, right?
We have a firm setting on the 18th.
And that's with Mr. Brinsky and Mr. Yeah.
And that goes till April.
That's a 3-week trial, right?
Yes. And we have 3 other cases on that same stack, so they might try and take up March 11th. And we won't know until this Thursday.
Your Honor, the 12th does work for Hanna.
You know what we can do? I mean, if we have time vacant on the stack, I would take it now, and if we have to adjust, we can adjust, but I think it's better to take that time now if we can.
If we do the 12th, it would only be in the afternoon. Because we have our normal morning calendars, Tuesdays, Wednesdays, and Thursdays, and that'll take a while. We can do the 11th or the 15th all day, but again, it might get moved because of trial settings.
I think we ought to do the 12th just because I don't think we have that much left, to be honest. 4 hours.
Yeah, well,
We have.
I'm the one who always
I would
says,
take what I can get.
yeah, I know, but I have to fly people in and all kinds of stuff.
When I go to
We can try, but I don't think we'll be done in 4 hours on it.
But we'll do the best we can, Mr. Polsenberg, and we can always come back.
Very good, Your Honor.
Your Honor, Joel Odou for Rural Water. I can do the 12th, the 13th, 14th, 15th I cannot do, and the 27th, 28th, and 29th I cannot do. We've got depositions in the other Rural Water cases.
We can also do the 11th and the 15th all
I
day.
can do the 11th and 12th, both of those days.
We can't do the 11th.
I can't do the 11th either.
How about the 12th?
That's
Yeah.
only the afternoon.
That's the day we're talking about.
yeah, why don't we try to do the 12th, the afternoon, try to get some more of it done.
We get some more done, and who knows, maybe
Some of these,
the other 3 cases won't get set on this stack. Maybe they settle, and maybe we'll have more time down the road.
1 p.m. on the 12th.
1:30.
Thank you.
And then there's a motion to redact and seal on Wednesday, the 28th. Do you want to move that to that?
I think
same
that's
time?
unopposed.
Yeah, that's an, I think they.
Let's go ahead and grant it, son of a.
We can move it to today.
We'll move it to today. No opposition?
No opposition, no.
Jan, so we're coming back when, before you go?
March 12th at 1:30 p.m.
I guess we can tell Mr. Parker he can turn off his iPad.
Thank you, Your Honor.
Thank you.
Everyone have a good day.
Thank you.
Good evening.